What is default bail? Who can take advantage of it? Under what circumstances the bail of default is given? Let's know about the default bail today in this video. Hello friends, I am Dheeraj Pathak and you are with me on my YouTube channel Legal Reviews. If you feel good with my channel, then please like it. If you are new on my channel, then don't hesitate to subscribe it so that even more good videos can reach you. Default bail is a type of bail contained in section 167 subclause 2 of CRPC, also known as statutory bail. Default bail is granted only when the police fail to complete the investigation within a specified time period in respect of the allegations made in respect of an accused taken into judicial custody. The right to default bail under section 167 subclause 2 of the Criminal Procedure Code is not only a statutory right but also a part of the procedure established by law under section 21. Default bail is a technical bail in which the nature of the offence is not considered as the basis of the bail, but the only basis of the bail is to take advantage of the lapse of the police or investigation agency at the appropriate time. In respect of the accused taken into judicial custody, the police or investigation agency has to file the investigation report within a specified period in the court, for which different time limits are prescribed in different cases. If the police or investigation agency is unable to file the charge sheet in the court within the prescribed time limit, then it is considered the fault of the police or investigation agency. In such cases, if the charge sheet is not filed after the prescribed time limit for filing the charge sheet, and if the accused files an bail application in the court in the period between the gap of filing of the charge sheet by the police, then the default bail becomes the basis and bail is granted by the court only on the basis of police lapse without considering the nature of the offence. In criminal cases where it is not possible for the police to complete the investigation within 24 hours, the police produce the accused in the court and the police seek an order from the court for judicial custody. After the crime report is registered or the accused is taken into custody, the investigation is done by the police, in which inspection of the crime scene, the evidence of the witnesses, as well as various aspects of the crime are investigated, and this is recorded in a research diary which is called case diary. Under section 173 of the Code of Criminal Procedure, the police officer, after completing the necessary investigation of any crime, is bound to file a final report. This report is called a charge sheet. Different cases has been prescribed different time limit for filing the final report or charge sheet according to the nature of the offence. For most honorarium crimes, the police have 60 days to complete the investigation and file a final report or charge sheet in the court. In cases where the punishment is less than 10 years, a time limit of 60 days has been filed for filing the charge sheet. In such cases where the punishment is death or imprisonment for life or a minimum of 10 years, there a time limit of 90 days has been fixed for filing the charge sheet or final form. But in some special acts, there is a provision to give more time to the police or investigation agency to complete the investigation and file the charge sheet or final report. The Narcotic Drugs and Psychotropic Substance Act 1985 prescribes a time limit of 180 days for filing the final form or charge sheet by the investigation agency, which can be extended up to 1 year. The Unlawful Activities Prevention Act 1967 limits the filing of the final report to 90 days, which can be extended by another 90 days. But in these special cases, judicial order is required for extension of time. extension of period can be done only on the basis of report by the police prosecutor stating the progress of the investigation and reason for keeping the accused in custody. In this way, the bail of default is not a bail of merit, but the result of the lapse of the police or investigation agency. After being taken into judicial custody, 60 or 90 days for filing the final report or within a prescribed period, different period in a particular cases. If the police or investigation agency fails to file the charge sheet, then after the prescribed period for filing the charge sheet, and in such cases before the filing of the charge sheet, the accused makes an application for bail in the court and agrees to file the bail bond, then the court will release that person on bail. I will bring more interesting and informative things in the next video. Stay connected with my channel and keep supporting me.